did any harm to these
Will you
victims.
meet with them within the next 30 days? The last time I asked a question, you can say yes or no.
I can keep on answering it the same way. I can meet with them. My staff will meet with them. We have a staff member here
If you
today
can
who
meet with them, will you meet with them?
A sitting president sued the American taxpayer for $10 billion. Not a business rival, not a newspaper. The taxpayer, you. And the man who signed the government's side of that? Settlement. The man supposedly defending your money used to be that same president's personal lawyer. Today, senators from both parties, Democrat and Republican, do something refreshingly rare in Washington. They pull out the document he signed and read it back to him, out loud, line by line. And what's inside is worse than the headline. Watch this.
The United States, your signature, the United States releases, waives, acquits, and forever discharges each of the plaintiffs when it comes to tax liability. That's how it reads. It's pretty sweeping.
Releases, waives, acquits, and forever discharges. 4 words. Hold on to them, because in the end of this video, you'll understand exactly why a Republican senator called this document a blank check that nobody can even define. This is Carter McKenzie. We don't do outrage, we read the receipts. First, the backstory, because the timeline is half the story. In 2020, a contractor working for the IRS, a man named Charles Littlejohn, leaked Donald Trump's tax returns to the press. That was a genuine crime. Littlejohn was investigated, charged, and convicted for it. On that point, Trump was a real victim. Let's be fair and say it plainly, because being fair is the whole point of this channel. Here's where it turns strange. Years later, in 2026, now as president, Trump sued the IRS, tax agency of his own government, for $10 billion over that leak, and a Republican, Senator John Cornyn, immediately spots the problem. The leak happened in 2020, the lawsuit only came in 2026, and there is a 2-year statute of limitations. In plain English, that claim should have been dead on arrival years too late to bring.
Or we had to borrow it on the backs of our next generation. And so I am proud of the department saying enough is enough. The free ride is over. We're digging in. We're going to take, not only are we just going to, talk about it, we're going to actually show you what we're doing. And we're going to create an entire different division. I think it speaks volumes that you have the new head of your fraud division with you today in the audience. I think America should know that. That didn't exist before you. I would like for you to tell the American people right now a little bit about that, because I have to tell you, when some of these states learned about this fraud going on, when Nick Shirley showed up and exposed some of this insane fraud that was happening right under state administration government's noses, the reaction from state leadership, and the governor of Minnesota called Shirley far-right delusional conspiracy theorist, maybe because he campaigned on these small businesses that were set up with that money so that the American people, we are growing small businesses, make me your vice president. Maybe that's why he had to knock Nick Shirley down a notch. Governor Newsom came out and said, slow, Shirley is the fraud.
So you have a $10 billion lawsuit that, by the government's own rules, was probably time barred. Normally, the Justice Department raises that, gets the case thrown out, and protects. The Treasury, that's its job. Instead, the man who signed the government's response was Todd Blanche, Trump's former personal criminal defense lawyer, now up for Attorney General. So, Trump's ex-lawyer is signing for the other side, against Trump. Hold that image, because now we read what he actually agreed to. Senator Durbin doesn't paraphrase. He reads the signed text back to the man who signed it.
I want to ask you about the immunity provisions that you signed relative to the responsibility and liability of the president and his family and their businesses when it comes to tax audits. Would you like to explain how we can give to the president and his family and businesses exemptions from complying with the tax laws of the United States?
Let's translate the legalese, because this is exactly where they hope your eyes glaze over. Release, waive, acquit, forever discharge, stacked together like that, those four verbs mean one thing. Whatever the plaintiffs might owe, or might have done wrong on past taxes, the government agrees to let it go permanently. Not review it, not audit it. Let it go forever, now. Listen to what Blanche concedes on the record. A release like this has never been done for a president before. That's Blanche's own answer, under oath. Now sit with why that matters to you specifically. If you underpay your taxes, even by honest mistake, you can be audited, fined, and in serious cases, prosecuted. There is no forever discharge waiting for you or me. This one document manufactures exactly that for one family, signed by that family's former lawyer. And if you think that's the strangest thing in the paper, watch a Republican Senator Cornyn pick up the very same document.
I want to ask you about the release, and I know I'm guilty of what a lot of lawyers are guilty of in having a chart you can't read, but I know you're familiar with this document, which is the release that you signed on May the 19th, 2026. First of all, does this purport to release parties or people who were not parties to the lawsuit?
No, Senator.
Well, it says here that claims asserted by defendants or any of the plaintiffs or related or affiliated individuals, including without limitation family.
Read it with him slowly, because the words matter. The release doesn't just cover Trump. It covers family, others filing jointly, trusts, parent, sister, or related companies, affiliates or subsidiaries, people and entities that were never even parties to the lawsuit. Think about what that does. A, settlement is supposed to release the people who actually sued. This one reaches out and wraps a protective blanket around an entire orbit, relatives, businesses, trusts that were nowhere near the case. And then Cornyn finds the detail that should alarm you no matter who you voted for.
This purports to release lawfare or weaponization and/or weaponization. Those aren't legal terms of art, are they?
I think they are just legal terms of art. They're not, there's not
Have
any.
they been defined in any case or any statute?
Not that I'm aware of, no.
So they're not a legal term of art.
Well, I think that the terms have been used by the legal community and by people within government, but no, I'm not sure that they're in Black's Law Dictionary.
So
for
we don't
example.
know what that covers.
Well, I think it depends on the circumstances of the facts presented as to whether it covers. As to what it covers, sorry.
Thank you. My time's up.
Lawfare, weaponization. A Republican senator gets Blanche to admit under oath that these words are not defined in any statute, not in any law, not even in Black's Law Dictionary. Now, follow that to the end. If the words describing what's being forgiven have no legal definition, then nobody, not you, not a judge, not the IRS, can actually say how far this release reaches. Cornyn's own conclusion. We don't know what that covers. That's not loyally nitpicking. In the real world, a release you cannot define is a signature on a blank page. Someone gets to fill in the amount later. So step back and ask the obvious question. Why would the government ever sign something this sweeping, this vague, this one-sided in the president's favor? Senator Welch answers it with one analogy you won't be able to unhear.
Would be analogous if the governor of Vermont sued the Department of Taxes for $10 billion. And we don't appoint attorney generals, but in New Hampshire they do, but let's say we did. And the governor's formerly personal attorney.
There's no comparison
Let me finish my question. The governor sues the Department of Taxes for $10 billion. His former personal attorney, who's now appointed attorney general, negotiates with the Department of Taxes and ends up settling by setting up a fund in the control, essentially, of the governor for $1.776 billion. That doesn't sound fishy to you?
Well, the hypo you just described, I don't think it's appropriate to use the word fishy. It's either ethical or not ethical, and there's
Vermonters would just say it stinks. I mean, that is truly bizarre that the chief executive gets his appointed person, who was formerly his personal attorney, to negotiate on his behalf, where at the end of the day, taxpayers are going to pay. So I'll just.
Here's the number underneath all of it. $9 million. That's what Blanche's law firm was. Paid while he was Trump's personal lawyer, straight from his own financial disclosures. Welch's point is devastatingly simple. You would never let a government attorney who owns $9 million of a company's stock sit down and negotiate against that same company on the public's behalf. Every ethics rule in the building forbids it. But swap the company for the president himself, and that is precisely what happened here. And it gets thinner still. When senators press Blanche on who actually wrote the language he signed, he says he cannot name the person who drafted the very document forgiving his former client. His answer to the whole thing? Don't call it fishy, call it ethical or not. Welch's reply says it best. A Vermonter would just say it. Stinks.
Was there any improper coordination of any kind between the Department of Justice and the Trump team as to this settlement?
No, not at all.
Okay. So, in fact, the case itself was settled based on an apology without any compensation being awarded, without the president receiving a penny. Isn't that right?
Correct, and completely consistent with the Federal Rule of Civil Procedure 41, which absolutely allows what happened here to happen. It happens in hundreds, if not thousands, of cases around the country every year.
For any entity, whether it's the U.S. government or otherwise, that's been sued for $10 billion or any significant sum of money, that seems like a pretty darn good deal.
Now the receipts cut both ways, and if I only showed you one side, I'd be no better than the rage channels. So here is the strongest version of Blanche's defense, and it is not nothing. His side goes like this. Trump really was the victim of a crime when his returns were leaked. The Perina case ultimately settled for an apology. The president received, in Blanche's words, not a penny. And a voluntary dismissal like this is allowed under Rule 41 of Civil Procedure at Mind. Happens in thousands of cases a year. On the cash, that's true. No money was handed to Trump. Fair enough. But here's why that defense misses the target. The scandal was never that Trump pocketed cash. The scandal is the release, the forever discharge, the undefined weaponization, the family and trust swept in, the 2-year statute of limitations that should have killed the case, but somehow didn't. You don't need a single dollar to change hands for a document to hand someone a shield against future audits. And a shield signed by that person's own former lawyer is worth far more than any check. So here's what the paper actually says, stripped of all the shouting from both sides. A president's former lawyer signed a government document that forever discharges that president and an undefined orbit of relatives, trusts, and companies around him from tax liability on a claim that was probably too late to even bring, using words that no law defines. Is that a normal legal settlement, or is it a shield with a signature? Don't take my word for it. The hearing and the document are linked below. Read the language yourself, then tell me in the comments. This is Carter Mackenzie. We read the receipts, so you never have to take anyone's word for it, not theirs and not mine. A normal settlement or a signed shield? Vote below.